The National Endowment for Liberty presents At Issue, the in-depth forum on freedom in America today. Hello, I'm Mike Hayes. The host of At Issue is the physician, author, and former member of Congress, Ron Paul. Ron?
Thanks, Mike. If you've ever served on a jury, you've participated in one of the few times in which ordinary citizens wield real power in our political system. But chances are nobody bothered to tell you how much power you really had. In today's program, we'll tell you some things judges and lawyers don't want you to know.
Our program, as usual, will consist of our probe report on what's at issue, reactions from a group of average citizens somewhere in the country, and an in-depth analysis of the entire subject by our panel of experts. We'll begin our probe report, Power to the Jury, following this brief message.
This is one in a series of programs that takes a fresh look at critical issues affecting how you live and how you use your natural rights as an individual to make decisions about your life. At Issue is brought to you by the National Endowment for Liberty, because we agree with Thomas Jefferson that government governs best that governs least. The National Endowment for Liberty is a nonprofit, nonpartisan educational project. We do not accept state or federal funds. In fact, we don't count on any agency of government at any level to keep this program on the air. Instead, we count on the generous gifts of individuals, people just like you. Write to us at Post Office Box 580099, Houston, Texas 77058, or call us at 1-800-333-3545 and ask for extension 909. If you missed any part of this message, keep your pencil and paper handy. This information will be repeated.
A typical American courtroom. Here, day after day, week after week, the laws and the people of our nation meet face to face. In any individual case, it is a virtual certainty that the law was not passed with these precise circumstances in mind. It was passed by a busy legislature with 1,000 other things on its agenda and its mind. It won its passage most probably because a majority of the legislators thought it fit their ideological agenda, or would enhance their re-election chances, or was requested by a special interest to which they owed a favor. In most cases, they never even read the actual bill itself. Legislators are government employees, and so is the judge who presides in this room. In the whole process, there are only 2 points at which ordinary citizens get to make decisions. One is in the voting booth, and the other is here, in the jury box. Here, ordinary men and women make decisions on whether or not to take a person's property, liberty, even his life. They have the power to judge the facts of the case at hand. And when they want to exercise it, they also have the inherent power to judge the worthiness of the law itself.
In a criminal case, when a jury goes back and closes the door, they are a power unto themselves. They can do what they feel is right, notwithstanding what the instructions are. It is what 12 minds determine should be the appropriate verdict in that particular case.
These principles date back centuries. A famous case involved the Quaker leader William Penn.
William Penn, I guess, was where it all started. He was out preaching in the streets, got arrested for it. This was back in 1670. And even though it was very clear that he had been doing what was against the law at that time, preaching on the streets, the jury refused to convict him. The reaction of the judge was to send 4 of the jurors to jail because they hadn't followed his instructions. But a higher court overruled that and said that juries had the right to judge both the facts and the law. And that was really the beginning of the idea of jury nullification in British law, and then it came into American law.
The Penn jurors struck a blow for religious freedom. In the colonial United States, it was a case involving freedom of the press, which helped establish the right of juries to nullify bad laws.
A lot of journalists are familiar with the Peter Zenger case. What they may not realize is that was essentially a case of jury nullification. The jury ignored the instructions of the judge, And again, a very important precedent was set.
Half a century later, America's founding fathers recognized the importance of juries to the functioning of a free country. Jefferson called trial by jury the only anchor ever imagined by man by which a government can be held to the principles of its Constitution.
Up until about the middle of the 19th century, it was standard practice in this country for judges to instruct lawyers and for lawyers to instruct the juries on their right to judge both the law and the facts. And people such as the first Chief Justice, John Jay, Thomas Jefferson, and a panoply of famous legal scholars through American history have supported the concept.
Today, judges almost never instruct juries that they have the right to judge the law as well as the facts.
We've always tried to rely on the jury system, but jurors have an innate sense of what's right and what's wrong. That always seems to come through during a trial. But when they go back to the jury room, if a juror receives an instruction of law telling them that they have to follow the law, and they don't like the law, many jurors feel honor-bound to do that.
Concern about the dwindling power of juries has resulted in the birth of a citizens' campaign to bring about a change in the way judges instruct juries.
We're real careful to inform defendants of their rights. You have the right to remain silent. Anything you say may be used against you, all that stuff. We all know Miranda's by heart. We've seen it on television 2,000 times, right? But they don't read the jury its rights, do they? And the jury has plenty of rights. And one of the most important ones is to decide whether the law is just.
Most jurisdictions in this country today, if an attorney stands up and starts making arguments, telling juries that you have the right to go back and decide as to what you can do and what you can't do. You're a power unto yourself. Start to give the classic jury nullification argument. A judge would stop you as soon as he sensed that was happening, tell the jury to disregard it, sanction the lawyer, and tell the lawyer would be held in contempt of court if he continued arguing along those lines. So there's a very thin line that one has to walk when trying to talk to a jury about jury nullification.
But today you are the law. You are the law. Not some book, not the lawyers, not a marble statue, or the trappings of the court. See, those are just symbols of our desire to be just. If we are to have faith in justice, we need only to believe in ourselves and act with justice. See, I believe there is justice in our hearts.
In the movies, dramatic moments and happy endings abound. But preserving the rights of juries is important in real life, too. 12 honest people with justice in their hearts sitting in these chairs are the citizenry's ultimate defense against bad laws, corrupt officials, and government tyranny, all of which we surely have today, though we may disagree on exactly how much. Regardless, we cannot afford to see the power of the jury further eroded through design, neglect, or apathy. Sooner or later, the day will come when it will be needed desperately.
Remember when life was simpler and problems were solvable? When you could rely on good common sense and your own honesty and initiative to see you through? That was back before government regulation got so tangled up in our public and private lives, before paperwork and arbitrary rules took over and individual choice was locked out. The National Endowment for Liberty believes that most of our problems cannot be solved by government, that too much government is in itself a problem, not a solution. These programs are made possible as a public service by people who believe that moral and political rights go hand in hand with economic freedom. Write to us at Post Office Box 580099, Houston, Texas 77058. Or call us at 1-800-333-3545 and ask for extension 909. We are the National Endowment for Liberty. Liberty can set you free.
My jury experience, without anybody really talking about it, the jury began to get a sense of what was just in this. And you know, let's not find this guy guilty or not guilty based on the law. Let's find him guilty or not guilty based on whether we really think he should do the time.
Each week on At Issue, we show the probe report you've just seen to a group of citizens somewhere in the United States. What you're watching are the unrehearsed reactions of people in Tampa, Florida, to the probe report, Power to the Jury.
Lawyers were surprised because they didn't think we'd go this way at all. But after talking about it over a length of time, we realized that the guy had obviously broken the law, but he hadn't broken the law, we felt in our hearts, to the point of doing this longer sentence.
When it came to the decision, what we had with the law that they gave us, we had to make the decision according to that law, and I really was disappointed because I felt that justice was not served because the law did not fit the crime.
Okay, if you had been told at the point you got ready to go into that jury room that if you don't think the law fits in this case, you have the right to make the decision based on the fact that the law doesn't fit, do you think it would have impacted would have made a difference?
Yes, yes, I really do.
If someone's brought to trial and what the law says is one thing, but what you feel and you can convey to the jury, you know, in that room, if it's a bad law, then I think it's up to you, and you know it's a bad law, to express your opinion and state why, and then if the other people agree, then go from there. And then if they disagree, then they need to prove it to you.
Governments can make anything illegal, and that's the sad thing about other countries. And if you have juries that can reject the laws, then you have the ability to prevent the type of bizarre things that happen.
Let's take it one step further, backwards. How did we get into this position?
I almost think that it's because the judges do not feel that 12 ordinary people are capable of making more than a guilty or not guilty choice. I mean, throw that third one in and people will not be able to make a choice. And I think that maybe they just don't trust the jury system as they should, that ordinary people can decide whether someone's guilty, not guilty, or that the law does not apply in this case.
The law is made by, you know, biases, or is it really ethical? Or, you know, I don't think some of the legislators are very ethical, I guess.
Well, I can see how the jury idea here could be used as a tool in the legislative process. In other words, it's like giving feedback to these legislators about what people think about what's going on.
I think before any jury is elected to be a jury, they should see this. I'm serious. I really do.
I've never been in a jury, and I think it's great that I saw that because I learned a lot about it.
They actually put in a plug for our show there. Well, let's see how our panel of experts feels about this issue. Dr. Eugene Hickok is a professor at Dickinson College and a resident scholar at the Heritage Foundation. Larry Dodge is the founder of the Fully Informed Jury Amendment Organization. And our host and permanent panelist is the chairman of the National Endowment for Liberty, Ron Paul. Ron, do you agree with the research group that all jurors really ought to see that program?
It certainly sounds like a great idea to me. I think that's a good deal. And I'm going to do everything possible to get as many people to get introduced to this idea, and I'm delighted to have two experts here with whom I can discuss this with. You know, it wasn't too many years ago I was not very much aware of what jury nullification was all about. Matter of fact, I came across a book by Lysander Spooner, Trial by Jury, and I was really enlightened by this. And this fits very well into any individual, including myself, who at times feels very frustrated about big government. I mean, here we try to improve our government. We recently talked about reforming Congress and changing Congress, but what happens? 96, 98, 99% of them get reelected. So those who are unhappy and need something to do in order to change things, I mean, really, this idea, this concept really gives hope to a lot of people. It's a real eye-opener to a lot. It was an eye-opener to me, and I think it's going to be an eye-opener to a lot of people in the general public, not realizing that juries have rights and that they have a responsibility, not just to deal with that particular case, but also a very deep responsibility to judge our judges and to judge our lawmakers. And it's amazing now to me to realize that we went so many years and this was totally neglected. But Larry, I want to start by asking you a specific question. Those who disagree with us, that think that this is too much power for the individual, too much responsibility for the jury, they say, oh, this is going to lead to nothing but chaos. They're going to revoke laws and we'll have anarchy. What's your answer to that concern?
I can't see any possibility of it, Ron. For the first century that we were a nation, it was routine for the court to instruct the jury that you are judges both of law and of fact. And we didn't have any anarchy or chaos then. And matter of fact, we had the government under control of the people, which is the way it's supposed to be.
And government was a lot smaller, of course, at that particular time. It seems like they almost have to have these judges protecting the lawmakers, that they can't expose the jury to too much information in fear that they may rule in a different manner. Gene, as a teacher and professor and someone that's interested in constitutional law, is this an issue that's been of interest to you, and how do you see this fitting into our current events today?
Well, it's kind of a curious turn of events over the last 200 years. If you look at the start of the Republic, as was demonstrated in the piece before we started our discussion, it was very important to those who wrote the Constitution, and particularly to those who were opposed or worried about this new Constitution, that there be checks on government. Now, there were a couple of ways that the framers decided we could do that. One was a written Constitution, which had limited powers for the national government. Another was through a system of election and re-election, so that the citizens would always have the ability to decide who will make laws and to change those people if need be. But a very important part of it was the jury system. It was a fundamental way of ensuring two things. One, that the citizens, the average citizen, would participate in helping to frame laws and understand how laws operate in their communities. That's the idea of deciding law as well as fact. Right. In addition, it was a way of keeping an eye on the application of the laws, of ensuring that the citizen was active in the daily implementation of public policy. Those things gradually have escaped us over the years. That's not to say that we don't have a pretty faithful and a pretty good democracy. I think it's relatively strong. But this important aspect of it is missing, and that's one of the reasons why the debate that we're having today is so important.
Would this help us in any way when it comes to administrative law? So much of our law now isn't even in the regular courts, so few of our cases actually end up in the jury. And you know, you take the IRS and other agencies, we don't have a trial by jury. Yeah. Will the movement that you're heading up, Larry, help us in that way, or is that something that would come later? How do we deal with the problems of the administrative law that we have?
Well, administrative law can of course be challenged in court, and sometimes effectively is. And in some cases, as in tax law, if you do something bad enough, you do get a jury, and then you can go ahead and make your case to the jury that the law is bad. At the present time, that is a problem. Wherever you don't have a jury, you have a problem in controlling the government. This harks back to the Navigation Acts in the early part of our nation's history. In fact, before we were a nation, the British decided that we were supposed to route all trade through England and pay duties and taxes on it. But colonial juries would routinely let sea captains go, quit them, for disobeying, you know, the Navigation Act. So the British responded by inventing courts that didn't have juries, courts of admiralty, where they could go ahead and have trials that didn't have juries, because they very well realized that if the jury were able to make its decision, they would reject these laws. And so the same problem is here with us today, and it does need to be dealt with.
Mm-hmm. Yeah, I think the regulatory morass that we live in today and the need for administrative law cannot be dismissed easily. I mean, the fact is we have a far more complex world and a far more complex society than we did 200 years ago. On the other hand, that's also one of the major reasons you should argue for a stronger trial by jury system. Because in the end, it's a way of empowering citizens and a way of helping to make sure that most law isn't written by bureaucracy.
And I guess we have plenty of that today, and if we don't do something soon, I don't know what's going to happen. I think we're going to be overrun by the bureaucracy, and we can't even attack this bureaucracy if we can't get the people to speak out. If they feel frustrated with the elective process, this obviously is an alternative method whereby they can put restraints on big government.
Rod, this is a good time for us to perhaps take a short break. Hold that thought, and we'll return with more views and comments on the subject at issue in just a moment.
Throughout this series of programs, you will see ideas examined that affect every part of your life. We'll look at issues from a new angle, not from the left or the right, but from the perspective of individual liberty and responsibility. We believe our founding fathers were right. We are endowed by the Creator with certain inalienable rights, and among these is the right to life, liberty, and property. We do not accept your money transferred through state or federal government agencies. Instead, this series is funded by direct voluntary gifts from individuals. We are the National Endowment for Liberty. Call us right now, 1-800-333-3545, extension 909. For a transcript of this program, specify the subject and send $5 in a stamped self-addressed envelope to P.O. Box 580099, Houston, Texas 77058. The National Endowment for Liberty, providing information on America's most precious resource, individual freedom.
Gentlemen, we're back. Before the break, we came to a pretty obvious conclusion. One of the things that interests me is, how did the whole idea of trial by jury begin? Where did this all start?
I think that's an interesting point, because I think it's a little bit older than even our country. I know that our founders were well informed about it, and they incorporated it into our system of justice, and they endorsed it. But when really did this come about? It was for a few years before our founding that it was known.
It goes way back to the English tradition and the Magna Carta. The whole idea was that under a system of laws, the individuals who are supposed to be the objects of those laws help to frame them. That's what the Magna Carta was all about, and the trial by jury system was a way for individuals in a small town to help to decide and implement the laws that govern that town.
Larry, how do the judges prevent the jury from getting the information, and how would this work? I mean, let's say we have this concept reintroduced and it's accepted. How does the jury even make the decision on what they want to hear? The judge now comes up, and if there's information, he'll say, well, that's inadmissible in court. Well, how in a practical sense would this come about, where the jury could demand or ask for or get more information?
Well, we are holding conferences that discuss what access the jury will have to the evidence, and enlarging the amount of evidence and the degree of evidence and so forth that the jury can review before it makes a decision is definitely one of the points. So we've actually formulated not just one amendment, which would require that the jury be told it may judge both law and fact, but a series of them we're calling the Bill of Jury Rights, one of which would give the jury access to the full range of evidence they need to make their decisions.
And of course, they would be emphasized that they could rule on the law as well.
On the law as well. This is the reason that's been forgotten and is not used. In fact, that juries are now told that they may not judge the law stems from a decision by the Supreme Court in 1895 called the Sparf and Henson decision, where the Supreme Court decided that juries no longer had to be told that they had the power and the right to judge the law. So it would be up to the judge. Fortunately, people have remembered over time that part of the job of being a juror is to use your conscience, so they sometimes take the risk and do it anyway.
Gene, what's your idea about a voluntary jury? Is there any merit to considering making jury duty voluntary rather than compulsory?
I think there's some merit to that, because you're talking about individuals who have stated that they have an interest in the administration of justice in our system. One of the problems with the current jury system is you do sort of draft people, and that always carries some problems with it. You know, one of the real benefits of a reinvigorated trial by jury system along the lines we're talking about is it might remove some of the mystery surrounding the legal process. It might open that process up and help more citizens understand both its benefits and its problems.
Folks, our time's getting a little short. We're going to need to wind this up. So let me ask each of you to comment on the short run for a moment. Gene, what's the next step? What's the first thing that ought to happen to bring more power to the jury?
I think one of the things you can do is, in addition to programs such as this, is try to talk more about the notion of citizenship. It's a very common idea, it's a very common argument, but it's not heard much anymore. And if you talk about citizenship, and not just in terms of going out and voting and register to vote, but in terms of one's obligations towards self-government, and how trial by jury and jury service is one of those fundamental components of self-government, you might begin to erode some of the mystery behind what's going on and help to improve the situation.
And Larry, you've been living and breathing this issue for quite a while now. What's at the top of your wish list?
Well, Mike, we've been out in the streets trying to get a law passed by citizen initiative that would require judges to tell the jury you have these powers that you don't know about formally. We of course, then encourage people to get involved in that. One way to do that would be to contact the National Endowment for Liberty and ask how to get involved with our citizen initiative or with the legislative process, where we are trying to get the legislature to require by law that juries be so informed. Other than that, there's a number of informal things that can be done. We have literature to pass out, and some people are just standing out in front of courthouses handing literature to people and educating them on site, which seems to be working.
Ron, finally, what's your view?
Well, I think obviously we have to have informed citizens if we're going to have informed juries, and that's the key to it. They must be informed when they vote. They ought to be informed and willing to serve on juries. I like the idea of a voluntary jury. I think that goes along with freedom ideas. I think our greatest obstacle is overcoming the arrogance of judges. And if we have enough jurors who are well informed and willing to serve, I believe we can achieve that.
Well, that's where we'll have to leave it. I want to thank our panelists and you for being with us. We'll be back next week for another vital topic at issue. The National Endowment for Liberty would like to acknowledge the inspirational contribution of James Miller and the sponsors of At Issue, whose generous support makes these programs possible.